Live from Washington, D.C., Jay Sekulow Live. Phone lines are open for your questions right now. And now, Chief Counsel for the American Center for Law and Justice, Jay Sekulow.
Well, it's a tie vote, a 4-4 vote out of the Supreme Court in the United States on the issue of the president's executive action on immigration reform, as he called it. That was the executive action that changed and would have really given status to almost 45 million people in the United States illegally. A 4-4 decision means that this Fifth Circuit decision blocking the president's law stays in effect. So this is a loss for the Obama administration. They have lost their ability to change the executive action, the laws on immigration. We got involved in this case very early on. I testified before the Senate on this, the House on the issue of immigration reform, about presidents engaging in actions that violate what's called the separation of powers. That is, we have three co-equal branches of government. The legislative branch is the branch that determines whether, in fact, laws are made. The president's job is to faithfully execute those laws, but presidents, or as I said at that hearing, impatient presidents don't get to change the law on their own, which is precisely what was happening. Van, this is something we've been involved in really since it first happened, and the end result is, not surprisingly, if Justice Scalia had not passed away, it would have been a 5-4, so you would have had a precedent. This doesn't create a precedent, but it does stop the law, so it's a win.
Well, it's a huge victory. It's a huge reprimand for the Obama administration, Jay, and there are going to be a lot of headlines that focus on immigration, and certainly there is a significant immigration impact here. But the most significant impact is one that deals with the separation of powers, and Jay, it goes back to the very first set of testimony that you made before the House Judiciary Committee in front of members with a very divergent views on the issue of immigration. You called them to defend their constitutional authority to write the laws in this area. And the decision that was affirmed today, Jay, was a victory for that separation of power, is a victory for the Congress's authority to write the laws. And it goes back to that very first argument you made. Congress writes the law in this area. The president simply cannot.
Yeah, I made a statement at that hearing that kind of became the thematic on this whole issue. Let me play a shortened version of it, because it really makes a difference when you got to frame the issues early on. Here we will frame it before the House Judiciary Committee. So to get the issue up, this was a big issue about, can presidents change the law on their own? The answer is no. It's again no by the Supreme Court. But here's what I closed with in that hearing.
Even with sympathy to the cause of immigration reform, impatient presidents may not violate the Constitution if they don't get their way.
And that's it. Impatient presidents don't get to do it. The president's speaking on it now. We'll have some of his words when we come back from the break. All right, we'll take your calls on this. It's a big win, folks. Folks, we're going to be taking a break, but as we do, let me encourage you to do something. We've put together a 5-point plan on the whole situation with radical jihadism that we're facing. It also includes immigration components, as we've been talking about the immigration issue here. We've got to know who's coming into the United States of America. We've got to know where their country of origin is. We have to know who they are. So all this is part of a 5-point plan we've put together. Will you sign on to that committee to defend the United States and defeat ISIS? You could do that at aclj.org or 1-877-989-2255. So it's aclj.org or 877-989-2255. Back with more in just a moment.
The Islamic State, ISIS, wants to destroy America and eradicate Christianity. Jihadists pledging allegiance to ISIS and radical Islam have attacked America, slaughtering dozens of Americans in multiple terrorist attacks. President Obama refuses to acknowledge the enemy. His administration has failed to protect us. ISIS is at war with us. We must wage war against ISIS. At the ACLJ, we've developed a critical 5-point strategy to defeat and destroy this jihadist enemy. We have 5 key steps to defeat ISIS. 1. Name the enemy, Islamic jihadists. 2. Fix our broken intelligence. 3. Ramp up undercover stings to smoke out jihadists at home. 4. Declare war on ISIS. And 5. Unleash full U.S. military might to utterly destroy ISIS. Stand with us. Add your name to our new petition right now. Call 1-877-989-2255. That's 1-877-989-2255, or add your name online, aclj.org.
Hey, well, if you're just joining us, we've got a decision in the executive action on immigration. The president, none too happy about it. I'm sure we'll get some of his statements up. In fact, they're going to play one for you. Here's what's happened. It's a 4-4 tie, which means the decision of the Fifth Circuit, which stopped the executive action, goes in force. And I said, even if you favored comprehensive immigration reform, and many people do, I favor comprehensive immigration reform, but presidents don't get to do that on their own. I mean, you got to have that's why you have a Congress. Laws have to be passed. You can't change the law on a signature. That the line, he had a pen and a pen and a phone, and he's going to change the law. It's not the way it works in the United States of America. Fortunately, we have a constitution that has the separation of powers. President Obama's reaction, none too happy, again being told that his actions violated the Constitution. Here's what he said, number 60.
These are students, they're teachers, they're doctors, they're lawyers. They're Americans in every way but on paper. And fortunately, today's decision does not affect this policy. It does not affect the existing dreamers.
This is all great, but if they're Americans in every way but on paper, they're not Americans. Because if you've immigrated to the United States like my grandfather did, you get papers that authorize your position in the United States of America. So, I know the president taught constitutional law, and nothing has changed since the Constitution was written in that regard, but apparently that is not where the president wants to go. We've got calls coming in. Let's go right to them. Susan's calling from Charleston, South Carolina. Susan, go ahead, please.
Yeah, hi. I just wanted to comment on the ruling today and say that President Obama has used his pen and an executive order basically to do whatever he wants. It's unconstitutional. And the comment that he just made about these people being Americans in every way, I beg to differ. I was in Southern California recently, and I saw lots of people that were protesting Donald Trump being there who were waving Mexican flags.
Well, here's the thing. You're not an American in every way if you don't have legal status to be in the United States of America. My grandfather immigrated to the United States. He was here legally, but it took him 15 years to get citizenship. So the president's statement, Stuman, is just factually incorrect. Now, I'll also tell you this. This was a big rebuke by Congress to the president, too. Dan, let's talk about that for a minute, because this is where the president was trying to overrun Congress, basically.
Yeah, well, first of all, what the president essentially said there is that they're Americans in every way except under the law. That's what he means by on paper. Under the law, we have rule of law in the United States of America. And in this realm, Congress gets to write the law. And I would just point out two things to the president. First of all, for 2 years after he took office, his party controlled both chambers. They could have rewritten the law with his support if they wanted to. And secondly, Jay, right before this executive order came down, and you have pointed this out many times, a Republican House and a Republican Senate was about to pass comprehensive immigration reform. It just didn't have everything that he wanted. And, Jay, he didn't want to lose political credit, so he jumped the gun, and he actually quashed that effort to rewrite the law in this regard. So he had two opportunities for the Congress to change this, and he skipped both of them.
The case is United States of America versus Texas. I'm holding in my hand for our audience that's watching us online or on Facebook and Periscope and watching us on television, that this is the brief we actually filed in the Supreme Court of the United States. Many of you, over 100,000 of you, were members of this brief. The end result is the president's executive action. Once again, his executive action is declared not valid, and that's not the first time that's happened. So we've had good success there. Paul Ryan spoke out on this as well, the Speaker of the House. Here's what he had to say.
I want to say a word about the Supreme Court ruling that we just got that halts the president's executive amnesty. This is a win for the Constitution. It's a win for Congress, and it's a win in our fight to restore the separation of powers. Presidents don't write laws. Congress writes laws. This is a case that the House weighed in on because it's fundamental to our system of checks and balances. Congress, not the president, writes our laws. And today, the Supreme Court validated that very core, essential, fundamental principle.
Yeah, so there I will tell you that then the truth is that our initial brief was probably the motivating factor to get Congress involved here.
Yeah, we represented 113 members of Congress, including 88 members of Speaker Ryan's House of Representatives at the Fifth Circuit, Jay. And because of that, the Speaker decided to intervene at the Supreme Court level. And by the way, attorneys for members of Congress actually got time to argue in this case. So like you said at the outset here, it was so important to set this narrative early on. We did it at the House Judiciary Committee. We did it at the early stages of the trial. And quite frankly, that's why Speaker Ryan chose to intervene at the Supreme Court. And ultimately, they carried the day.
This is an interesting comment that they're posting right now. We will have to abide by the Supreme Court's decision until November's election, said President Obama. I want to make sure that's an accurate translation of what he said, that they got it right on the news, and let's pull that sound if it is, because, boy, I will tell you something. Let me break it to you. You have to abide by the Supreme Court's decision past November's election, because you can't do it. The president, he'll have his days in office between the November election. Is he going to try it again? Supreme Court said no. The Fifth Circuit law stands. So, this is a way that he's going to, I think, the president's also saying we need a bipartisan approach to immigration reform. Well, guess what? You had one and you stopped it by jumping the gun. Arthur's calling from Lancaster, Pennsylvania. He's on line 4. Hi, Arthur.
Hi.
Yes, sir, you're on.
Okay, my question is, why is President Obama permitted to enact all these executive orders in the first place? Why is there not a mechanism within the government that makes him pass certain hurdles?
Well, there is. There is in the government. So the president has authority to issue executive actions, but those have to be based on existing law. So it's the implementation of existing law. And here's the check. It's the check we did. How do you stop unlawful actions of a president? That's why you have 3 articles of the Constitution: 1, 2, and 3. Article 3 is the courts. Guess what? Article 3 says the Supreme Court precedents have said this since Marbury versus Madison. If there's an action that violates the Constitution, the Supreme Court can declare it null and void. That's, in essence, by a 4-4 tie. They reaffirmed the Fifth Circuit decision, and the Fifth Circuit said the president's executive action was unconstitutional, violating separation of powers. So we didn't just, as I said, Arthur, and we say so many times in this broadcast, we didn't just talk about it. We engaged it in the courts, and we're successful. And it's then, I think it's important to point to, then we got involved in this really early on. Right when it first happened, we were on top of this case. From the moment the president signed the executive action, we were engaged at the highest levels.
Yeah, that's right. And this is that mechanism to trigger that check and balance. And I would just say, first of all, in this case, yes, very early on, we made the case to members who supported this kind of reform and who opposed it that they needed to stand up for their Article I powers. From the very beginning, that was the argument we made. That's the argument that carried the day. And I would also just point out, Jay, there are a couple of other cases very similar where this is the mechanism that has been used to check the president. You talk about the National Labor Relations Board case. You talk about the Obamacare subsidies case. In both situations, that required calling on the Article I branch, the legislature, to stand up to the Article II executive, take it to the Article III courts. And in all of those cases, Jay, we won, the president lost.
Yeah, and I tell you, continuously loses on these. He has not had a success on any executive action he's done in this regard. So I want people to have hope that we do have a system of government that works here, and this is a great example of how it works. Let's go to Roger's calling from Oregon. Hi, Roger.
Good morning, Jay.
Hey.
Jay, I have a concern here.
Yep.
I've been listening to your program this morning, and I'm pleased with the discussion. I'm also aware of Paul Ryan's comment as well.
Yep.
However, my focus and concern is with the 4 liberal justices who have ignored their responsibility. I mean, it is so obvious that there was not a separation of powers. I mean, Obama wanted to do what he wanted to do, however he wanted to do it, and they do not recognize that he basically usurped his authority and his power to enact a law.
Well, we don't know, but to be fair, Roger, we don't know, because this was just a per curiam order. It's a one-sentence order. It just says the decision of the Fifth Circuit Court of Appeals is affirmed. The court is divided 4-4, which is an affirmance of the lower court. The Fifth Circuit law stays in effect, and that said there was a violation of separation of power. So in respect to the justices, we don't know who was on which side, and we don't know what there was no dissenting opinions here. Sometimes you have that, no concurring opinions. But the key is the Supreme Court has blocked President Obama's immigration proposal, and that's the key. Steve on Twitter asked a similar question. He said, what about the 4 justices that thought the president had the authority to do this? Again, we don't know who those 4 are. We don't know what their positions would be. I would assume that they would have argued if they were going to issue if they felt strongly about it, they could have issued a dissenting opinion or an opinion. They did not. So it's very hard to say what it is. I will tell you this at the end of the day, and this is the good news. This was a big win for the Constitution. It would have been better if we had 5 justices on the court and had a full opinion. We don't. That's just not the way it is because of the death of our friend Justice Scalia. But nevertheless, we do have a victory here. We have a petition up about the ISIS and Islamic Jihad. We're going to get into that a little bit later in the broadcast and on tomorrow's broadcast as well. Professor Hutchinson is going to join us again. A little bit later in the broadcast, we're going to be joined by Congressman Jeff Duncan on the issue of Loretta Lynch saying all you need is love to beat the terrorists. We're going to talk about that. But we've got a petition up at aclj.org. Let me encourage you to go there. ACL, 48,000 signatures, by the way. We're marching towards 50,000 pretty quick. So ACLJ.org, that's ACLJ.org to sign that petition. And also, if you want to stand with the ACLJ, again, respond to our newsletters and emails that are coming out. You'll be getting one today as well. We encourage you to get those at ACLJ.org. It's a great way to sign up for those. I will take more of your calls when we come back from the break. Those phone lines are open, 1-800-684-3110. But a big win here. Supreme Court blocks President Obama's immigration proposal. That's called a victory. Back with more in a moment.
The Islamic State, ISIS, wants to destroy America and eradicate Christianity. Jihadists pledging allegiance to ISIS and radical Islam have attacked America, slaughtering dozens of Americans in multiple terrorist attacks. President Obama refuses to acknowledge the enemy. His administration has failed to protect us. ISIS is at war with us. We must wage war against ISIS. At the ACLJ, we've developed a critical 5-point strategy to defeat and destroy this jihadist enemy. We have 5 key steps to defeat ISIS. 1. Name the enemy, Islamic jihadists. 2. Fix our broken intelligence. 3. Ramp up undercover stings to smoke out jihadists at home. 4. Declare war on ISIS. And 5. Unleash full U.S. military might to utterly destroy ISIS. Stand with us. Add your name to our new petition right now. Call 1-877-989-2255. That's 1-877-989-2255, or add your name online, aclj.org.
So President Obama has a loss of the Supreme Court. The Supreme Court blocks his immigration proposal, that executive action. We filed a brief, holding that brief in our hand. This is the brief we filed with the Supreme Court of the United States. And by the way, many of you signed on to this brief. So you wonder, you say to yourself, does it make a difference if we sign a brief to the Supreme Court? Well, in this particular case, in the first round of this, we had members of Congress at the lower courts, which got them also to file a brief at the Supreme Court. And then we had a committee as well. And that committee had hundreds of thousands, I think 132,000 signatures or something close to it. I mean, it was well over 100,000 signatures on that committee. So that was good news, and the court blocked the order. So that means the executive action was stopped. That's the good news. President Obama, though, response to it, very interesting, typical President Obama kind of response. Here's number 61.
We have to follow now what has been ruled on in the Fifth Circuit because the Supreme Court could not resolve the issue. And we're going to have to abide by that ruling until an election and a confirmation of a 9th justice of the Supreme Court so that they can break this tie. Because we've always said that we are going to do what we can lawfully through executive action, but we can't go beyond that.
And the court said, by leaving the Fifth Circuit law in place, by the way, the Fifth Circuit is a federal court of appeals, said President violated the law, violated separation of powers. That immigration bill cannot go, or executive action cannot go into force. 340,000 of you signed our brief on that, which is, so I had the number off by almost more than half, which is an incredible response. Thank you for allowing us to do this. And listen, I'm in favor of comprehensive immigration reform, but you don't get to do that on your own. That was tried under President Bush. He wanted to get it done. Harry Reid blocked it. Let's not forget where this started. And the president had the House and the Senate for 2 years, Stan, and did nothing to get this through.
He had it for 2 years, did not make it a priority, chose Obamacare instead. And, Jay, he also had an opportunity to work with Republicans in Congress who were ready to pass a bill, and he chose instead to go it on his own and really block that legislative effort. And I would just quickly point out, if the Fifth Circuit had ruled for the president and the Supreme Court had affirmed that decision 4-4, just like they affirmed this decision today, the president would not be saying this was unresolved. The president lost today, and he's saying it's unresolved because he doesn't like the ruling he got.
And there's no, let me tell you, no doubt about that. This is a careful phrasing by the president. All right, we're taking more of your calls as well. Tom's calling from Phoenix, Arizona. He's on line 5. Hi, Tom.
Yeah, so I was asking, I know you kind of answered some of them but earlier, but how the 4 Supreme Court members could not see it as the rest of us, that it's unconstitutional.
Yeah. Well, here's what I want to say, Tom. Look, we don't know even who those 4 were, so it's speculation. I have guesses on who I think it would be, but who knows? We don't know. What we do know is this: if Justice Scalia was alive, we would have had a 5-4 decision that would have had a substantive discussion on what the law is. Instead, because of his untimely passing. 4-4 tie means the Fifth Circuit law stays in place. The Fifth Circuit law is very clear. President Obama violated the separation of powers. It was executive action overreach. He doesn't get to change the laws on his own. Impatient presidents don't get to just modify what laws they like or don't like, and that is it. But it is literally a one-sentence order. The judgment is affirmed by an equally divided court. That's what they do when they do this. Sometimes they can issue concurring opinions or statements. They did not in this particular case. And it's interesting also here that the court and the lower courts rejected all of the theories put forward by the government, and the government lawyers have got themselves in a lot of trouble over this case for some misrepresentations. So this case has had big ramifications, a big loss for the Obama administration, but also tells you Supreme Court appointments really matter, and there is one for sure. David's calling from Oregon. Hi, David.
Thanks for taking my call.
Sure.
I want to just follow up. I think it was glossed over, and I'm 100% in agreement with you on this issue. But the condition of the court is my concern. It really doesn't matter who the four are. The fact that it was split 4-4 and it wasn't an 8-0 decision, as blatant as the overreach was, is very, very disconcerting.
Yeah. Well, look, I mean, I'm with you in the sense I don't think this was a close case. I thought this was an easy call. I thought that the president doesn't. This was a change of law. The president. Do we have the bite where the president says I've changed the law? I mean, I know we played that in the open. I mean, presidents don't get to change. That's a Constitution Law 101. But here's what the University of Chicago constitutional law professor, this is what he had to say.
You're absolutely right that there have been significant numbers of deportations. That's true. But what you're not paying attention to is the fact that I just took an action to change the law. Now,
oh, and they're clapping and they're applauding, and this is great. The president took an action to change the law. The only problem with that is he has no constitutional authority to do it. And then again, people can be how happy they are about it, but the reality is this was an unconstitutional act of the president, period. And it was also a thumbing in the eye of the United States Congress.
The president tried to play king and legislature all at once. Fortunately, the judicial branch stepped in and prevented that from happening. Listen, I would say something quickly to the last caller, Tom. Our way of government does have a couple of unique characteristics. Yep. One is the co-equal branches of government have to stand up for themselves. That's what happened here. So when you get a win using that form of government, Jay, you take it. And secondly, I would say this. If you're worried about the makeup of the court, as are many of us, elections have consequences, and both of these candidates should be pressed to the limit about how they will fill that open seat and the ones that will follow it.
We're going to take some more calls. We're going to go to Donna, who is calling from California on line 2. Hi, Donna.
Hi, Jay. Thank you for your important work. Thank you for taking my call.
Sure, my pleasure.
I wondered how and when immigration laws have changed since all my 4 grandparents came with a destination, with money in their pocket, with a will to work, and they responded when somebody asked for, can you do this job? They had to be physically able and not diseased. They had to be no police records. When did all this change?
Really, in the 70s and 80s. I mean, it's been that my grandparents came through Ellis. Where did your grandparents come in? Where were they coming from, Donna?
Eastern Europe.
Yeah,
to Ellis Island.
Same thing. Mine were from Russia and Poland. But it really, I mean, Ellis Island, that really stopped being utilized as a port of entry in the late 20s, early 30s. But the laws really changed radically in the last decades. But then remember, this is illegal immigration. And that's what we got to stress. They don't use Ellis Island anymore, but there's a process for legal immigration. And this is the great problem here is that this is illegal immigration.
Well, that's exactly right. And a lot of the proponents of the president's executive order, Jay, will point to the 1986 change, which was one of the most recent ones passed by a Democrat Congress, enforced by 2 Republican presidents as rationale for what the president did here. There's only one difference. Congress passed a law to change the immigration laws in that place. And in this case, the president just moved forward on his own. So it's a very different scenario, whether you support those changes or you don't.
Yep. Let's go to Kathy. Try to take a call before the break here. Hi, Kathy.
Hi, Jay. Good morning. I wanted to know if you could elaborate a little bit on the comment that you made about Obama saying that he was going to revisit this in November.
He said, what are the implications? He has to hold on until the election and then revisit it, and look at the election in the Supreme Court. Well, the election's irrelevant. The president doesn't have the authority to make this he can't do this again. He may try to do it in another way, though. And I think, look, the day after, from November, the date of the election, till the next president's sworn in. That's 71 days. Then we're going to have to be on our toes because a lot of things can happen, especially in the Middle East, folks. I've got a whole team dealing with what the president may try to do to Israel and force negotiations.
Yeah, no question about it. The president is hoping to do this in one of two ways. One, he is hoping for that 9th seat on the Supreme Court. That would take some time for it to trickle up and do it. But, Jay, I would especially argue that between the new Congress being sworn in and when the president leaves, about a 3-week period, depending on the makeup of Congress, look out. You never know what that Congress would send the president in the waning weeks of his term.
We've got our teams ready, okay? Our teams are ready. But it's going to be a real fight. Let me say this also. I'm going to talk about this on the broadcast tomorrow. This refugee situation is serious. We believe in in-country aid, in-region aid, as we call it. But the fact of the matter is, there is a situation. A report just came out. Jeff Sessions and our friend Senator Ted Cruz have both put this forward. 580 convictions since 9/11 on terror-related charges. 380 of those were foreign-born, so they were foreigners in the United States. At least 24 were initially admitted to the United States as refugees, and at least 33 had overstayed their visas. And additionally, 131 additional individuals have been implicated in terrorism since early 2014. These haven't been convicted, and there are newer cases. At least 54 of these individuals are foreign-born. 16 of them initially admitted to the United States as refugees. So when the Department of Justice head, the FBI head, says we can't verify who's there, and the CIA director says they're going to use the refugee routes as a way to infiltrate, I'm going to take their words for it. Well, that's going to do it for the broadcast, folks, but I need you to take action. We've laid out a comprehensive 5-point plan on how to deal with the issue of terrorism. We've been talking about this immigration reform issue. Look, securing our borders is an important part of understanding how you protect us from terrorism. So we want to encourage you to take action with us. We presented these 5 points to the United States Congress. We need your help. We've had, I think, over 100,000 signatures on this already. More coming. But go to aclj.org and sign on to this petition to defend America. Defeat the terrorists, but defend the United States. Sign that petition for defeating ISIS at aclj.org and support our work at the ACLJ. You can do that by just making a donation at aclj.org. aclj.org. or 1-877-989-2255. It's 877-989-2255 or aclj.org. We'll see you next week.
The Islamic State, ISIS, wants to destroy America and eradicate Christianity. Jihadists pledging allegiance to ISIS and radical Islam have attacked America, slaughtering dozens of Americans in multiple terrorist attacks. President Obama refuses to acknowledge the enemy. His administration has failed to protect us. ISIS is at war with us. We must wage war against ISIS. At the ACLJ, we've developed a critical 5-point strategy to defeat and destroy this jihadist enemy. We have 5 key steps to defeat ISIS. 1. Name the enemy, Islamic jihadists. 2. Fix our broken intelligence. 3. Ramp up undercover stings to smoke out jihadists at home. 4. Declare war on ISIS. And 5. Unleash full U.S. military might to utterly destroy ISIS. Stand with us. Add your name to our new petition right now. Call 1-877-989-2255. That's 1-877-989-2255. Or add your name online, aclj.org.